Yay, yay. West Coast Rider coming up behind you. Welcome to the Badwolf Show. Now you know we gotta go. I don't really rap, but that is my flow. You can't deny it. I'm a rider. I'm glad you're ready to go. That's all I got. All right. So, what is this video about? Well, one of my clients, viewers, students, slash, and multiple other people have come to me because they lost their court cases, and that's why they came to me to try to help them out with whatever. So for those of you that don't know, I do court cases. It's normally going to cost you about $500 for that. To take a look. Obviously, we don't make any practice promises, and this is a private consult only. Okay, we're not licensed. We're not going to make that. Do operate as an attorney in fact, because I'm going to turn over some facts for that ass. All right. That being the case, you do have remedy because one, if your counsel didn't do things properly, that's malpractice or negligence on behalf of the of counsel, and that can sometimes get your case either thrown out. It can get them to review it, re-review it. Sometimes it can get you some leeway, but you have to be able to articulate what they did wrong. So we're going to take a look at malpractice on behalf of these attorneys. Now, hold on, let me just. Okay, for some reason my internet was moving really slow. I think it looks like it's okay now. I'm probably gonna have to get a new computer. Might be my RAM, or maybe I had the computer on too long or something. All right, so let's take a look. So a shot goes out to mbroker.com. All right. 10 common mistakes that can lead to legal malpractice claims and how to avoid them. So fair use. All right. And we're going to have it read from here. So let's take a look or a listen.
A very high degree of professional care. Any time an attorney fails to meet the expected standards of his or her profession, their clients could take legal actions against them for what is called legal malpractice. Legal malpractice claims most often occur when a professional decision or action made by an attorney results in losses for his or her clients, who will then seek to recover these losses by way of a legal malpractice action. While it's true that not every mistake that an attorney makes can be considered grounds for legal malpractice actions, it's also true that many very common professional mistakes affecting nearly every area of the law regularly lead to professional liability claims. Let's take a look at not only some of the common ways in which lawyers can slip up professionally that could lead to legal malpractice claims, but also what attorneys can do to minimize these common mistakes and their chances of being sued. Missed deadlines. Cases of missed deadlines in the legal profession are most commonly linked to attorneys failing to file documents in time. There are several deadlines that need to be met whenever attorneys have to file court documents, and failing to meet these deadlines can have negative consequences for their clients and, in turn, themselves. When an attorney fails to file documents on time, their clients can lose significant amounts of money, not to mention that in some instances, failing to file documents in time can lead to a case being thrown out of court entirely. Another common mistake that's related to deadlines is often referred to as a failure to calendar properly. This means that the attorney may have been aware of certain deadlines but failed to schedule them for some reason. This can lead to missed hearings, missing documents, and consequentially, sometimes leads to a default judgment against the client. Misuse of finances. When a client pays a retainer, their attorney must put that money into a trust account. If the attorney puts this money into his or her personal account, this can be considered financial misuse. Of course, The most
Okay, so now that's interesting, okay, because I always thought that they just put it into their own personal account. So they're saying that they have to put this money into a trust account. So if that's the case, you guys can get them for misuse of finances. Because really, you should be able to contact their trust or however they have that set up and be like, hey, they didn't do their job and I want a refund. So instead of having to deal with the attorney, you need to go to be able to go to them. So this is something new I just learned, and that's interesting. This is another tactic to use. A lot of people are like, yeah, they won't give me my money back, or they're like, yeah, I'm not giving you your money back. Sue me or whatever else. Well, okay. Well, did you put that money in your own personal account or is it held in trust? Personal account, good. I'm going to sue you for misuse of finances. Trust account, okay. I'm going to go talk to them about getting my money back.
Most extreme example of legal malpractice related to a misuse of funds would be if an attorney were to steal funds from their clients outright. Inadequate investigation or discovery. One professional responsibility all lawyers take on when they agree to take a case is to put in the proper amount of time and effort investigating their client's legal actions. This phase of the legal process is referred to as discovery, which is a series of legal mechanisms that attorneys use to put together evidence that will help their clients' cases. If an attorney does not perform a sufficient investigation and fails to discover facts that are important to a particular case, such as failing to identify a key witness, they could be liable for legal malpractice. Errors in communication. Communication is a very important part of the lawyer-client relationship, and poor communication is one of the main reasons why clients take their attorneys to court. If an attorney is not returning their clients' calls and cannot show evidence as to why the lack of communication was warranted, a claim could be filed against them. Failure to inform is one of the most common reasons for legal malpractice claims. This means that the attorney, for whatever reason, did not provide information to his or her client that was considered relevant or important to a case.
Another way of looking at it is also inadequate counsel. You can use that in your case. Your Honor, my counsel is inept, inadequate counsel. So yeah, these are all things you can use to get your case re-examined, reopened, re-adjudicated.
Case. Failure to know and or apply the law. Obviously, lawyers are expected to have a working understanding of all pertinent areas of law in which they are practicing and the know-how to apply the law correctly. If the attorney doesn't apply a law correctly, misunderstands it, or fails to keep up with changes that have been made to laws within his or her jurisdiction, a legal malpractice claim could be on its way. Lack of consent. While attorneys are hired by clients to represent them in legal matters, that doesn't mean that they receive carte blanche when it comes to decision-making. A lawyer must always have the consent of the client before taking any legal action. In the relationship between client and attorney, the clients outline their objectives while the attorneys put together a strategy that they believe will allow these objectives to be reached. However, the attorney cannot proceed with his or her strategy if the client does not consent to it. Any time an attorney acts legally without the expressed written or verbal consent of a client, that attorney opens himself or herself up to a potential legal malpractice claim. Fraud. This one is fairly clear-cut. If an attorney deceives the client or anyone else involved in a legal process in order to obtain unlawful gain, there's a good chance that they have committed fraud. If a client has any reason to believe that something like this occurred, he or she can file a legal malpractice claim against the attorney. Failure to follow instructions. Similar to taking legal action without the consent of a client, lawyers can also be accused of legal malpractice if they refuse to follow instructions given by their clients. At the end of the day, the client is paying the attorney for legal representation and the attorney is obligated to follow instructions. If the attorney believes that it would not be beneficial to carry out these wishes, they may say so, but they cannot refuse to follow instructions if the client has made up his or her mind and instructed them which course of legal action they would like to take. Errors in strategy or planning. If a choice of strategy or improper planning leads to losses suffered by the client, an attorney can be liable for professional negligence. Errors related to strategy and planning are generally looked at as errors in judgment regarding how a client's legal matter should have been handled.
Yeah,
Conflict of
because
interest.
your counsel is inadequate, meaning I could have probably won it, but my lawyer was stupid, dumb, all these things, whatever it was, they cost me time and money in my case. You can use that.
Interest. The definition of conflict of interest is pretty straightforward.
P.S. By the way, we're not powered or paid by a broker. So like once again, fair use. So this is out there on the internet. So we're just doing commentary on this. All right. We're not sponsored by them, et cetera, et cetera. They're not sponsored by us.
Straightforward. If an attorney puts his or her interests ahead of the client's interests, that constitutes a conflict in interest. Additionally, putting one client's interests above another client's interests can also be considered to be a conflict of interest and an example of legal malpractice. There are many different examples of conflict of interest: failure to provide full disclosure, having a personal relationship with a member of the opposing party, client or attorney, intentional professional misconduct of any kind, representing two parties on the same side of a dispute that have conflicting interests between themselves, working for a percentage of a client's business transactions instead of a regular professional fee, and so on.
And when they say so on, what they also didn't put in there, which is the big one, is financial. If your lawyer or attorney or whoever can profit from your failure, same thing with the judge. Okay. If they can make money on your downfall, that's a conflict of interest. If the judge makes money, what they call is policing for profit or court for profit, say like judge makes a nickel on his stocks every time somebody buys handcuffs or buys handcuffs, and those handcuffs are issued from uh, the courthouse. He's got the conflict of interest. He may not even know it, but that is a way to get him recused. And if he's profiting off of people, he can be terminated if he's policing for profit.
On.
Okay, so this goes on to just kind of help lawyers and attorneys, be selective with your cases, consult other attorneys, have a contract, set proper expectations, be meticulous to documentation, secure insurance. So, once again, guys, it's all about finding the imperfections, the problems, the errors, anything to make your scenario that they think has been perfected and showing that it has not been. I call it the thousand cuts of victory. One cut may not do it, but if you start lining up all the imperfections, and sometimes one cut will do it. But if it doesn't, you want to stack the cards like always in your favor. And as I had to tell my young cousin, the house always wins. Understand that you, as a casino, you can't put out more money than you're winning. So that means unless you're Trump and then you are putting out more money than you're winning, which that there's a strategy you can for that too, believe it or not. You can use that for many different things, lots of write-offs especially. It means that whoever it is, whatever house, they're setting themselves up to win. And if you notice, the courthouses aren't going anywhere. So the house always wins, or in this case, wins way more than it loses. Otherwise, they wouldn't be profitable and they wouldn't be there because these courts are for profit. They're making money in the millions of dollars, to put it nicely. Got to really wonder where all that money's going. Hmm, just saying. It ain't all going where you think it's going. But anyway, guys, that's it. So once again, if that's what your lawyer or attorney or whoever is doing, you just learn two things. One, you can use that to help to reverse possibly your case. Two, you can sue them, get your money back, and then some. Okay? Okay. Talk to you guys later. Bad Wolf's out. Without a doubt, like a scout on a new route.